Morning, I'm Rakiyah Lenon. I am reporting for the Bell Ranker, Augusta University student newspaper. Today I am joined by Frank LoMonte. LaMonte is an attorney for CNN in Atlanta. Great you can join us today.
Thanks so much for the invitation.
No problem. So you're expert in the First Amendment, and I'd like to ask you a few questions concerning that. So what are the major concerns the general public tends to have about the First Amendment or free speech in general?
Oh my gosh, how much time do we have? I mean, it's a big issue and it's just in the headlines each and every day, right? I mean, there can't go a day without a court case or a piece of legislation that somehow bears on the right to speak or to publish online. I think for the general public, right, for people who are not kind of working in newsrooms every day, the biggest set of concerns revolves around the role of social media and platforms in policing speech and kind of what the right role for them is, which is not really a First Amendment issue at all, since Twitter and Facebook and Instagram are private organizations. They're really not bound by the Constitution, even though from time to time people will go to court and try to hold them liable for First Amendment violations. The First Amendment only comes into play when you're talking about a government actor, and that's not Twitter and Instagram and Facebook. But I think people are really concerned, as they probably should be, that these platforms have so much power to be kind of choke points of the public dialogue, and have they gotten too much power? Have they accumulated kind of too big of a share of the public discourse so that when they change their policies, it kind of changes the public discourse? And on the other hand, I think there are people who feel like maybe the moderation doesn't go far enough, that they should be doing more to screen out things like propaganda and conspiracy theories. And it's a really hard tightrope for those organizations to walk.
Mm-hmm. And what are some ways the First Amendment you feel is being abused or not being interpreted correctly?
Oh gosh, yeah. So, I mean, when we talk about the First Amendment being abused, I don't think that I don't think that people, quote unquote, abuse it in the sense that they're engaging in speech out there on the fringes or out there on the edges. I think you could actually argue that speech on the fringes is what the First Amendment was intended to protect. There's I think a sense among the general public that maybe some speech that's hateful or angry or inaccurate should be unprotected by the First Amendment. But the founders never said that, and the courts have never said that. You get to be hateful and angry and even false, and you're still within the boundaries of the First Amendment unless you cross some pretty extreme lines. You defame somebody, you threaten violence against them, you steal their copyright protected property. Now you're departing from the protection of the First Amendment. But as long as you don't do any of those things, the First Amendment applies. But I do think that there's a lot of miscommunication and misunderstanding about what is and is not covered. And I do think that, unfortunately, the courts have been inadequately protective of vulnerable speakers like government employees, like students in colleges and high schools, people who are kind of uniquely subject to being retaliated against and who really need the clearest protection, the assurance that they could speak about matters of public concern without being punished for it. And I think the courts have kind of failed us and fallen short in giving those clear assurances and clear guidelines for the authority figures to follow too. I mean, if I'm a supervisor at a government agency, I need to know where does my authority begin and end, and the courts have really fallen down on the job there.
And earlier you mentioned about social media, and so I wanted to ask, how has social media really changed what people think about the First Amendment with the freedom to post things and all kinds of different texts, whether that be videos or live streaming? So could you tell me a little bit about how social media has kind of impacted the way we view the First Amendment as well?
Yeah, I mean, I've used the phrase before that I think the First Amendment in today's dialogue is a little bit of a damaged brand, that people invoke the First Amendment typically when there's a crisis going on, when there's a dispute about things like hateful or extreme speech. And so that over time, those two things have become associated with one another, right? When you hear First Amendment, you kind of think right away, oh, I know what's coming next. This is going to be neo-Nazi or anti-Semitic speech of some kind of extreme hateful speech. And of course, the First Amendment protects so much more than that. And it really is what gives the ability to engage in discourse about matters of social and political concern, and to kind of move that discourse forward, right? If the government was able to shut down opinions just because they were extreme or non-majoritarian, then you couldn't bring about social change, right? Because all social movements depend on being able to say things that are outside of the mainstream or outside of the majority. So, I do think that because the discourse on social media can get really toxic at times, and people can be victimized by trolling and other kinds of antisocial behavior, that it does maybe weaken and undermine people's otherwise extreme adherence to the First Amendment, right? People are sort of willing to compromise their otherwise loyalty to freedom of speech on the grounds that, well, wait a second, this goes too far. This isn't what we meant by freedom of speech. We didn't mean freedom to troll. And that's a really challenging, and I don't think we have a perfect answer to it. Is there a point at which letting some people speak online actually shuts down or silences other people? That's the hardest to me of all free speech issues, is when you have a speaker on both sides of the equation. You have speakers trying to be heard, trying to make a point, and other people are trying to shout them down, right? Well, you've got speakers on both sides, and who do we put the thumb on the scale in favor of? And I think the platforms have sort of taken a let it all hang out approach, right? Let everybody speak and let the marketplace sort it out. And typically, that's their right? And they also have First Amendment rights. A platform has a First Amendment right to decide what do we host and what do we not host, and the government can't dictate what they host and don't host. But yeah, I think that it's just going to be a constant kind of a tweaking process to figure out what's the right amount of speech to let in and what's the right amount of speech to exclude, and what standards should we use.
Mm-hmm. And I wanted to ask a little bit more about things on the journalism side, so far as freedom of the press. And it's been almost 6 decades since the New York Times versus Sullivan case. And would challenging this case even be possible in the court of law? And if so, how would it affect journalists?
Well, so we used to think that New York Times versus Sullivan, right, which is the case that sort of raised the bar for a person who is a public official to bring a defamation case against a speaker, against a publisher. We used to think that that was rock solid legal precedent, and decades of future court cases have been built around it, right? Many decades of lower court cases have built upon and clarified and expanded upon the Sullivan Doctrine. So it's kind of foundational to our understanding of the rights of speakers and publishers. And normally you don't remove the foundation. But this particular Supreme Court has shown that it's willing to revisit some of the things we used to think were settled bedrock legal principles. So I would never rule that out. I would never say that that's impossible. And then certainly there is a growing kind of chorus of voices out there. Both Justice Thomas and Justice Gorsuch have indicated some willingness to revisit the principle and maybe move the line a little bit more in favor of the person who's being spoken about and against the speaker, make it easier to prevail on the defamation claim. And so there's definitely this view is kind of moving its way into the mainstream of political discourse. My caution anytime you change a settled legal principle like that would be you always have to think about what the unintended consequences might be. I think a lot of people who would revisit Sullivan and would make it easier to bring those defamation cases are thinking about the New York Timeses and the Washington Posts of the world, the big players, the big publishers. But if you lower the threshold to bring a defamation case, frankly, that's also going to hit people who publish on Wikipedia and people who publish on Yelp, people who, unlike the Times and the Post, don't have a staff of lawyers and outside legal counsel standing by on the phone. And so that, Joe citizen, Joe internet user is also going to be a potential libel defendant because frankly, almost all of us are publishing now, right, in some form. And lots of us are sharing our opinions and our thoughts about public figures, about politicians, about people in the news. And if you're going to make it easier for those people to bring libel cases and get damages, then you're kind of opening up the possibility that just everyday, ordinary citizen commentators are going to find themselves on the receiving end of a lawsuit, and even if they end up prevailing, just defending that suit could be a crushing expense to them.
And in your talk last night, you mentioned about the importance of accessing information, and I wanted to ask you, how effective is the Georgia Open Records Act?
Well, the Georgia Open Records Act is actually one of my favorites in the country. I've done a lot of looking at all 50 state laws, and it's not the broadest, it's not the strongest, but it has some features in it that I think are kind of worth emulating by other states. I mean, one of the things that is important in Georgia is that it actually sets a deadline for agencies to respond to furnish you with records. Many states, including Florida, where I used to work, they just tell agencies to respond within a quote-unquote reasonable time. And reasonable time is an invitation to abuse. It's an invitation to delay. And many agencies take fullest advantage of that and exploit it. And so the fact that there are hard and fast deadlines in the Georgia statute, that's very helpful. And there are criminal penalties for people who are flagrant abusers, and we've actually seen those criminal penalties used a handful of times. That's fairly rare that states will do that states will go as far as to actually put teeth into the law, where if you are an especially flagrant abuser, you destroy records knowing that people are requesting them and they need them, that you actually might find yourself paying a fine or even in an extreme case going to jail. So the Georgia law is one of the stronger ones in the country. That being said, people do often express frustration with it, that it doesn't work nearly well enough, that there are exemptions, that kind of the whole can eat the donut sometimes, that the exemptions are so broad. Things like law enforcement records are a constant source of frustration that people need, and that law enforcement agents have kind of a blanket license to withhold. And so that license probably needs to be revisited and narrowed so that it's only the most essential critical records that are, things like the names of a confidential police informant or something can be withheld from the public. That makes good sense, but not anything and everything concerning crimes, right? And so I do think it's time for all legislatures, including Georgia's, to kind of go back to first principles and think about, well, why did we create these exemptions in the first place? Why do we carve out these categories that people can't see? And could we tighten up and narrow that language, knowing that it often gets abused by agencies and, frankly, just in furtherance of their secrecy agenda?
And lastly, we are at a university, and so I wanted to ask, what are some things that student journalists should know about their First Amendment rights?
Well, so one of the important things for student journalists to know is that just because they're working inside the confines of a public university, that doesn't mean that somehow the university has total and complete authority over them and that the First Amendment somehow ceases to exist. The U.S. Supreme Court has actually been really protective of the rights of college student speakers. I think there's been 4 cases over the history of the court where college students have challenged censorship by their universities, and in all 4 cases, the students have prevailed and the universities have lost. So the courts are ready to step in there if it turns out that universities are really crossing the line and censoring or trying to dictate what students can say. There was a famous case back in the 70s called the Papish case, involving a student at University of Missouri who started her own magazine, basically, and it was a magazine that kind of anticipated the Black Lives Matter movement. It was very harshly critical of police, and it used some really strong anti-police language, and she was expelled from college for doing this, and the Supreme Court said, no, reinstate her, that's a First Amendment violation. So the First Amendment has real force on college campuses. Colleges, state universities anyway, are government actors and government officials, and they have to obey the First Amendment. I also think it's really important for college journalists to know how to use those open records and open meetings laws. Those very much apply to public universities, just like any other state agency. They apply to Board of Regents at the state level. And that's a really powerful tool, if you're good at using it, to be able to inform the public about what's going on and where their tax dollars are going.
That's all, and thank you so much again for joining us, and we're glad that you can be here today.
Thanks for the opportunity to visit your beautiful campus.
Thank you.